Welcome to law classes. Today I am going to discuss with you one of the most important topic called Indian Partnership Act 1932. Indian Partnership Act 1932 deals with various provisions regarding the business firm which is formed under the Partnership Act. And also we will see what do you mean by partnership, what are the do's and don'ts in a Partnership Act, and also we will discuss regarding the rights and liability of each partner, and tests determine the various tests to determine the Partnership Act. In fact, Indian Partnership Act 1932 as if you see the Indian Partnership Act 1932 has a co-partnership relationship with the Indian Contract Act 1832. Originally, Indian Contract Act 1872, when it was formed, it has 266 sections and 11 chapters. The 266 sections has now the 266 section has been divided into various parts in 11 chapters. Now, Indian Contract Act originally contained 6 chapters. That is section number 1 to section number 75. That is called General Principles of Contract. Chapter number 7 onwards, that is section number 76 to section number 123, is known as Special Contract called Sale of Goods Act. Chapter number 8, that is 124 to 147, has become the Contract of Indemnity and Contract of Guarantee. And chapter number 9 has become the Contract of Bailment. Chapter number 9 is called, that is section number 182 to section number 232. It is called the Contract of Agency. And chapter number 11, that is 239 to 266. 239 to 266 is known as Indian Partnership Act 1932. That is also a part of a contract. Definitely partnership is a contract. Coming slides will elaborate you the various listing of the partnership. We will see in the coming slides what do you mean by partnership, what do you mean by partnership firm, what are the do's and don'ts of a partnership. We will see in the coming slides. Coming slides will elaborate regarding the provisions of Indian Partnership Act 1930. As I told you in my earlier classes, these are all comes under the ambit of mercantile law. Mercantile law is normally taught in almost all universities in India. All universities in India, mercantile law has been taught for the BCom, BBA, and also this class will be of very great use to the students who are undergoing the courses like this CA foundation and all these things. It will be of great use. So we will see what you mean by Indian Partnership Act 1932. As I told you, it has a origin from Indian Contract Act 1872. In fact, partnership is also a contract only. Nothing but it is a contract only. Partnership is a contract only, but a little bit different from the general principle. All the essential things of the contract like section 11, section 10, all are applicable to here also. It is a special type of contract. We will see what is that one by one. What is a partnership? Anybody may have a doubt in your mind. What do you mean by a partnership? As it is there in your slide, you can see in this slide, partnership is a relation between persons who have agreed to share the profit of a business carried on by all or any one of them acting on behalf of them. It therefore follows that a partnership consists of 3 essential elements. Partnership consists of 3 essential elements. First one, it must be a result of an agreement between the 2 or more persons. Partnership is a result of an agreement between 2 or more persons. Essential condition, there should be 2 persons or more number of persons can be there in the partnership. Agreement must be, second condition, the agreement must be to share the profit of the business. Agreement must be to share the profit of the business. Third condition, the business must be carried on by all or any one of them acting for all. The business must be, all the partner can participate in the business or any one of them acting, carrying the representative capacity of the other partners also can. All these essential must coexist before a partnership can come into existence. All these three essential conditions has to be fulfilled before a partnership has come into existence. We will see what are the essential elements of a partnership. First is the agreement. What are the essential elements of a partnership? You may not have. One is the agreement. Partnership must be the result of an agreement between two or more persons. An agreement from which the relationship of a partner arises, it may be expressed or implied also. And also the partnership must show the mutual understanding between them. It may be oral or in writing. Either it can be, agreement may be expressed or implied. Even implied agency also may attain the status of a partnership, but certain conditions, subject to certain condition. We can see that in the coming slides. The agreement may be oral also, or it can be in writing also. Okay, second we will see what is the second condition. Second element, second most essential element of a partnership is sharing of profit of the business. There must exist a business, that is trade. It can be a trade, it can be occupation, and a profession also. The motive of business is acquisition of gain. Therefore, there can be no partnership. Therefore, there can be no partnership where there is no intention to carry on a business and to share the profits. I think this sentence is very important. It should be for the, either for the trade or for an occupation or for a profession. For example, you can see an advocate, two, three lawyers or advocates or solicitors can join together and form an association or a firm or a partnership. This partnership is to carry out the advocacy profession, to file briefs and take cases of the clients who are come, and all these things, whether it may be the individual client or company, whatever it is, it can be. For these three purposes only, mainly partnership must be formed. And the take-home point is that sharing of profit of the business is the most essential ingredient of a partnership. Secondly, there must be an agreement to share the profits. The agreement to share the losses is not an essential element. Sharing of profit is okay. Then you have to share the losses also. But what the Act says is that you need not be, that need not be an essential element of a partnership. However, in the event of the losses, unless agreed otherwise, there must be borne on profit sharing ratio. Losses also to be shared on the same ratio like the profit has been shared. Understood? Okay. Third, business carried on all or any of them acting for all. Each partner carries on the business as a principal as well as an agent on behalf of the other partner. This is a cardinal principle of partnership act. Therefore, true test of partnership is mutual agency rather than sharing of profits. As I told you in my earlier classes, the most conclusive test to form a partnership is the sharing of profits. Sharing of profit is a conclusive test to determine whether a firm is a partnership or not. The sharing of profit or loss returns from the property of any person holding joint or common interest in the property would not by itself make such person a partner. Although the right to participate in the profit is a strong test of partnership, and there may be cases where upon a simple participation in profits, there is a partnership. Yet, whether the relationship does or does not exist must depend on the whole contract between the party. Here, you have to understand one thing. Suppose 2-3 people together own a land or a building. On a land or building. That land you are letting out, renting out or something like that. 2-3 houses you built. You divided that into first floor, second floor and all. And you are renting out to 2-3 different tenants. And you are getting the monthly rent or whatever it is. That will not constitute a partnership. Joint ownership of a property is not a partnership. Coming slides will elaborate you more on that. But the task becomes difficult when either there is no specific agreement or agreement in such as does not specially speak of partnership. In such a case, for trusting the existence or otherwise of a partnership, Section 6 has to be referred. According to this section, regard must be had to real relation between the parties as shown by the relevant facts taken together. Person who have entered into a partnership with one another is called individual partners and collectively, and the name under which the business is carried on is called firm's name. Partnership is merely an abstract legal relation between the parties. A firm is a concrete thing signifying the collective entity for all the partners. Partnership is thus that invisibility which binds the partners together, and firm is visible form of these partners who are thus bound together. It is very clear from this slide that individually they are known as partners, collectively they are known as firm. Collectively they are known as firm. Okay, this is a distinction between the partnership and the firm. We will see what is the comparison between partnership and the joint stock company. What is the difference between partnership and joint stock company, or otherwise it is called a company or it is called a corporate. Okay, yeah, first we will classify this based on these parameters. One is personality. Firm is not a legal entity. Please remember, partnership firm is not a juristic person at all. It has no legal personality distinct from its personalities of its constituent members. On the other hand, a registered company is a juristic person distinct from its members. Second, agency. In the firm, every partner is an agent of other partner as well as that of a firm. But in this case of the company, a member is not an agent of the other members or the company. That is, as I told you, the test of the partnership. Mutual agency. Mutual agency is lacking in corporate. It is there in the partnership. Okay, distribution of profits. Third parameter. We will compare between the corporate, the partnership, and the corporate. Third parameter is the distribution of profits. The profit of a firm must be distributed among the partners according to the term of partnership firm, but there is no such compulsion in case of a company. It is very clear. Profit has to be equally distributed among the partners. There is no such compulsion in a corporate sector. Extent of liability. In the firm, liability of partner is unlimited. Mark this point. Unlimited liability. While in case of a company, liability of shareholder is limited to the amount, if any, unpaid on the shares. In case of a limited by shares, otherwise, if there is limited by guarantee, the guaranteed amount liable to the extent of either unpaid amount of the share or guaranteed amount of the share. Okay, fifth parameter we will compare is property. The firm property is that which is the joint state of all partners as distinguished from the separate state of any of them, and it does not belong to a body distinct from its members. So, in case of insolvency, the joint estate after meeting the liability in respect of a joint debt devolves on the partners. Mark this sentence. Devolves on the partners. Unlimited liability. Second, we will see seventh parameter, management. In the absence of any express agreement, to the contrary, all the partners are entitled to participate in the management firm, but members of the company are not entitled to participate in the management unless they have been appointed as directors. That is, shareholder, as you know, the difference between shareholder and the member of the company, more or less nowadays it is interchangeably used, but either shareholder or the members who are the absolute owners of the company doesn't have any right to participate in the management of the company unless and otherwise the member has been appointed as a director of that company. You don't have any right to participate in the day-to-day affairs of the company. But it is contrary in case of partnership. In case of partnership, all the partners have a right to participate in the management of the firm. 8. We will compare the number of membership. In case of a firm carrying banking business, the number of members cannot exceed 10, but otherwise 20. A private company may have as many as 50 members, but not less than 2. And a public company may have any number of members, but not less than 7. Public company can have unlimited number of members, but it should not be lesser than 7. Private company is concerned, it is limited to 50. It is limited to 50. We will compare partnership versus club. We will see what you club. Most of you will be a member of some clubs or something like that, some various clubs. Lions Club, Rotary Club, and various clubs are to promote sports activities, to promote cultural activities and others. We will see what is the difference between partnership and the club. A club is an association of persons formed with the objective not of earning profits, but promoting some beneficial purposes such as improvement of health or providing recreation for the members extra. On the other hand, partnership in association of persons formed with the objective of earning profits. Objective of forming the partnership is to make profits. Okay. Unlike a partner, a member of a club is not an agent of the other, nor is he liable to a creditor of the club, except when he is responsible for the contract which gave rise to liability. A member of a club, suppose a club incurs some debts, member of a club's property, personal property, cannot attach, or even you cannot ask a member. You are a Lions Club member, your Lions Club International has made us a lot of debts. Why don't you can pay? We will say, sorry, I am just a member of a club and I don't have mutual agency. And second point, we will see a member of a club has no interest in the property of the club, as a partner has in the property of the firm. Also, the change in the member of a club does not affect its existence. Third, creation. We will compare partnership versus HUF, Hindu Undivided Family. Okay. We will compare based on various parameters like 1, creation. Okay, creation. The slide will show creation. 1. The relation of a partnership is created necessarily by an agreement, whereas the right in joint family is created by status. As I told, the co-parcenary relationship has been created by status. The creation of a right by status means it is a creation by birth in that family. Suppose I born in a Hindu undivided family and I have the right by birth. I become a co-parsoner or whatever it is, member of a Hindu undivided family. All members may not be co-parsoner, as you know, but this membership in HUF I attained by my birth. Nobody can deny. Nobody in this world can deny that. To death of a partner ordinarily leads to a dissolution of partnership. Please understand, underline this. If you are noting down, please note down this point. Death of a partner come to an end of a partnership. But death of a member of a Hindu undivided family does not give rise to dissolution of the family business. Nothing will happen in death. Another person, it will devolve. Management. We will compare partnership versus HUF, Hindu undivided family, on this parameter, management. Right of management of joint family business generally vests in Karta of HUF, where the governing male member of a family, Karta is the governing male member of a family, means head of the family. Normally, Karta is the head of the family. But in case of partnership, all members are equally entitled to take part in the partnership business. Unless otherwise, there is an agreement contrary to which. Okay. Fourth parameter, we will see authority to bind the firm. In joint family, karta or manager. Karta and manager is not the same. Karta is not a manager, ideally speaking. But we will consider him as a man who controls or man who does all the job on behalf of the others. Is known as karta, as authority to contract for the family business. In partnership, every partner can, by this act, bind the firm. If a one partner entered into a contract, other partner is also liable. Even for his wrongdoing, other partners are liable. But in case of Hindu undivided family, only the karta of Hindu undivided family can enter into a contract with them. Or any person who delegated by karta can also. Fifth parameter we are comparing between partnership and HUF is the liability. In a partnership, the liability of partner is unlimited. Liability of partner is unlimited. But in a Hindu undivided family, only the liability of karta is unlimited, and the other co-partners are liable only to the extent of their share in the profits of the family business, unless they take part in the act performed or transaction ended by the karta. Liability, only karta is answerable for the for the liabilities or debts, whatever he has endured. The creditors cannot ask in the members. Creditors cannot go there. If at all there is any personal or private property of the members, he cannot attach. That is the essence of it. Sixth parameter, calling for accounts. On separation of a joint family, a member is not entitled to ask for accounts of the family business, but a partner can bring a suit against the firm for accounts, provided he also seeks dissolution of the firm. It is very clear. Partner can ask the accounts of the firm if he asks for a dissolution, but it is not so a person who was separated from the HUF through after he would have filed the discharge or something like that. He would have given the discharge to the rest of this thing. He cannot ask for the accounts and all this. Governing law. A partnership is governed by Partnership Act, whereas Hindu HUF is governed by which law? Hindu laws like Hindu Succession Act and all these things. Yes, Hindu Succession Act and all these things will be. Okay. Second, we will compare this parameter, minor's capacity. We will see what is a minor's capacity in partnership, and what we will see what is a minor capacity in HUF. In a partnership, a minor cannot become a partner, though can be admitted to the benefit of the partnership only with the consent of all partners. In a Hindu undivided family business, a minor become a member of the ancestral business by the incidence of birth itself. He does not have to wait for attaining majority. Continuity. A joint Hindu family has a continuity till it is divided. The status of joint Hindu family is not thereby affected by death of a member, but a firm is subject to a contract between the partner get dissolved by the death or insolvency of a partner. We will compare partnership with co-ownership. We will see what is the difference between a partnership and what is the difference between a co-ownership. Partnership always arises out of a contract, either express or implied, whether it is in writing or in oral, whatever it is. Implied or co-ownership may arise either from an agreement or by the operation of law, such as inheritance. Partnership is always a result of a contract. Very clear. But it may not be with always it may not be with the co-ownership. Suppose a person called, for example, what you call X dies. He has got two sons, X1 and X2. Two sons called X1 and X2. They, what you call, after his only two legal heirs. His wife predeceased him. We will think like that. No other legal heirs are there. So X1 and X2 will become co-ownership by the operation of law itself, not by an agreement. So that is the first difference. Second, partnership is a partnership. There is a community interest. Mutual agency, I told you. Community interest. Each partner is responsible for the action of other partner. They are Mutually, they enjoying the agency, and there is a community interest. It means that profit and losses must have to be shared. But co-ownership does not necessarily involve sharing of profits and losses. Understood? Suppose I own a property, a building, something has happened to that property, some debts are happened, floods to that property. I have some other business. I don't have any community interest with my co-owner. That is a take-home point. In case of a partnership, a partner is the agent of the other partner. But in case of a co-ownership, a co-owner is not an agent of other co-owner. Very clear. A share in the partnership is transferred only by the consent of the other partner. Co-ownership may be dissolved at the will of the co-owners. Also, a co-owner may transfer his interest or rights in the property without the consent of the co-owners. Okay, it is also clear. And we will compare partnership versus association. Partnership means and involves setting up a relationship between two or more persons who have entered into a business for gains with the intention of share the profits of such a business. But membership does not exist between members of a charitable society or religious association or an improvement scheme or a building corporation, etc. It is okay. Second style. Partnership does not exist between members of mutual insurance society. Third parameter. In a trade combine or protection associations, the relationship between the member is not that of partnership. Types of partnership. We will see the types of partnership. This is, I think, it is very important in the examination point of view for especially BCom, BBA students, and also those who are preparing for CSCA and foundation courses. Types of partners. One, partner by holding out. Section 28 of the Indian Partnership Act, 1932, deals with types of partners. And one is a partner by holding out. A person may himself, by his words or conduct, have induced others to believe that he is a partner, or he may have allowed others to represent him as a partner, though actually he is not. He is liable like a partner in the firm to anyone who, on the faith of such a representation, has given credit to him. The result is both the cases identical. The result of both the cases is identical. Partnership by holding out is also known as partnership by estoppel. Ideally, he is not a really he is not a partner, but his action and his conduct made him somebody to believe that he is a partner, and they entered into contract with him. And contract is going also. After some time, other partners may holding out this thing particular. He will co-opt him as a partner. That is called partnership by estoppel or partnership by holding out. Section 28 of the Indian Partnership Act deals with that. Second, sub-partnership. A sub-partnership may arise when a consequent upon an agreement between a partner in a firm and a stranger. The latter is vested with the interest jointly with that of a partner, so far as his share in the firm is concerned. Such an agreement will not render the stranger a partner of the main firm. A sub-partner can claim the agreed share from the actual partner, but he can have no right against the main firm to take part in or to interfere with its business or to examine its accounts. This agreement is between the partner and the stranger only. He cannot come to the partnership at any cost. He can settle with the partner who entered into an agreement with him also. Other partner may not be liable. Other partner may not be liable for this type of activity unless there is an agreement contrary to which. Minor's position in a partnership. Even though a minor cannot be a partner in a firm, he can nonetheless to be admitted to the benefit of the partnership under Section 30 of that. In other words, he can be validly given a share in the partnership profits. Partnership profits. Please mark this word. When this has been done, It can be done with the consent of all the partners. Then the rights and liability of such partner will be governed under Section 30 of the Indian Partnership Act 1932 as follows. We will see what the Section 30 says. We will see what are the rights of a minor. Under Section 30 of the Indian Partnership Act 1932 deals with the rights and liabilities of a minor, if at all. We will see in this slide what are the rights of a minor. First right, a minor partner has a right to his agreed share of the profits of the firm. Clear? Two, he can have access to, inspect and copy the accounts of the firm. Third, he can sue the partner for accounts or for the payment of his share, but only when he severed the relationship, when he closed the relationship, or when he closed his connection with the firm, not otherwise. He can sue the other partner once he decided to cut his relationship with the other partner. Sever the relationship, when he's severing the relationship, or when he disconnects his relationship with the other partner, he can sue. Otherwise, he cannot sue. Because partnership is a mutual agency. Okay. Fourth right of a minor is that it's a most important right. On attaining the majority, he may within 6 months elect to become a partner, or not to become a partner. Within 6 months, he has to decide whether he is continuing in this partnership, whether he elects to continue his partner, or he decides to disconnect himself and he is going out from that. If he elects to become a partner, then he is entitled to the share to which he is entitled as a minor. If he does not elect to become a partner, then his share is not liable for any acts of the firm after the date of the public notice served to this effect. If he does not elect, then his share is not liable for any acts of the firm after the date of the public notice served to that effect. Okay. Then now we will see what are the liabilities of minor. Minor's position in partnership, what is his liabilities? First, the liability of minor. The minor share is liable for the acts of the firm, but he is not personally liable for any such acts. So here liability of minor is limited here. That is the first point. Limited to the extent of the share in the partnership, not to his within 6 months of his attaining majority, or on his obtaining knowledge that he had been admitted to the benefit of the partnership, whichever date is later, he may give a public notice that he has elected not to become a partner, and such a notice shall determine his position as regard to the firm. Clear? If he fails to give such a notice, he shall become a partner in the firm on the expiry of the said 6 months. If the minor become a partner of his own willingness, or by his failure to give the public notice within a specified time, also the position will be as follows. First, if he fails to give the public notice, or he not opts out, what is his position? He become personally liable to third parties for all acts of the firm. Then, since he has admitted to the benefit of the partnership, he is personally liable. Limited liability, that immunity has been taken away. Second, his share in the profit, his share in the property and profit of the firm remains the same to which he was entitled as a minor. That is no ambiguity on that. Mutual rights and duty. We will see now the mutual rights and duty of the partners. Okay. In the contract may provide that a partner shall not carry on any business other than that of the firm while he is a partner. Subject to a contract between the partner, the mutual rights and liabilities are afterwards. This is again subject to the agreement analysis. Rights. Right to take part in the conduct of the business. What are the rights of a partnership? First right is to take part to participate in the business. Every partner has a right to take part in the business unless there is an agreement contrary to that. Second point is that now suppose this management power of a particular partner is inferred with, and he has been wrongfully precluded from participating there. Can the court interfere in these circumstances? Here is a question. The answer is in the affirmative. Court can and will by injunction. These are the remedies available. Suppose due to some various reason, suppose I am a partner in a firm called what you call DK firm. I am not allowed to participate. They are not allowing me to participate in the day-to-day business. What are the remedies available? First remedy is I can seek an injunction. I can restrain the other partner from doing so. These are the remedies available. Second right of the partner is the right to be consulted. Where any difference arises between the partners with regard to the business of the firm, it shall be determined by the views of the majority among the partners, and every partner shall give the right. Every partner shall have the right to express his opinion before the matter is decided. But no change in the nature of the business of the firm can be made without the consent of all the partners. Suppose I am doing a business of selling the books selling. I'm selling the books to various people. Suppose I decided to have a printing press to print the books and this publishing house. Now I am only a bookseller. I have to get the consent of not the majority, all the partners. Section 12, subclause C deals with that. Rights to remuneration. No partner is entitled to receive any remuneration, no salary, nothing. In addition to share in the profits. Because partnership is basically to share the profits, not to earn salary. Interest in the capital. The interest will be payable only out of profits. As a general rule, interest on the capital subscribed by the partner is not allowed unless there is an agreement or usage to that effect. Because I'm investing some 10 lakhs in a partnership firm, am I entitled for interest if I ask? Truly speaking, no, I am not entitled for any of the interest. The principle underlying this provision of law is that regard to the capital brought by the partner in the business, he is not a creditor of the firm, but an adventure. I am not a creditor of the firm, I am an adventure. I am doing an adventure only, not the money lending business. Interest on advances. The partner is entitled to claim interest thereon at the rate of 6% per annum, as envisaged in the section 13 subclause D. While interest in the capital account ceases to run in dissolution, interest on advances keep running even after dissolution and up to the date of marriage. Right to share profits. Partner are entitled to share equally the profits as mentioned in the section 13 subclause B. Seventh right is to right to examine the books of account. Every partner, whether active or sleeping partner, is entitled to have access to any books of accounts and inspect and take a copy out of it. Indian Partnership Act, section 12, subclause D, deal with that. Mutual rights and duties of a partner again is the right to be indemnified. Every partner has the right to be indemnified by the firm with respect of the payment made and liabilities incurred by him in the ordinary and proper conduct of the business, as well as in the performance of an act in an emergency for protecting the firm from any losses. Subclause section 13 subclause E of the Indian Partnership Act 1932 deal with that. Right to stop admission of a new partner. Every partner has the right to stop introduction of a new partner without the consent of other partner. And also right to retire. Every partner has a right to retire with the consent of other partner, and in case of partnership by will, by giving a notice to the effect on all the partners. Section 32 of the Indian Partnership Act. Right not to be expelled. No partner can be expelled by other. Section 33 deal with that. Right to dissolve the firm. Every partner has a right to dissolve the partnership with the consent of other partners, and in case of a partnership by will, by any partner giving a notice to that effect to all other partners. Section 40 deal with that. Right of the outgoing partner to carry on the competing business. An outgoing partner can carry on the competing business with the firm, and he may advertise such a business, but without using the firm's name. He should not say that I was previously a partner of that firm. This partner is a subsidiary of that firm. We enjoy a what you call buy-buy relationship. We enjoy buy-buy relationship. No such thing. Then we will see what are the duties of a partner. Partner are bound to carry on business of the firm. Second, he has to work for the greatest common advantage. He has to be just and faithful to each other. He has to render to any partner or any his legal representative a true account and full information of all things affecting the firm. Section 9 deal with that. Every partner is liable to indemnify the firm for any damage caused by his action. Every partner is bound to attend diligently and is diligently to his duties relating to the conduct of the business. Section 12 bar B, Section 12 subclause B deal with that. All the partners are liable to contribute equally to the losses sustained by the firm. Fifth is that if a partner derives any profit, private profit for himself from any transaction of the firm or from the use of the property or the business connection of the firm or the firm's name, then he is bound to account for the profit and refund it to the firm. Section 16, subclause A of the Indian Partnership Act deals with that. A partner must identify the firm for any loss caused by it by willful neglect of the business of the firm. 7. If a partner carries on business of the same nature as and competing with that of the firm, then he must account for and pay to the firm all the profits made by him in the business, and the firm is not liable for any loss. Okay, then we will see this part, that is personal profit earned by the partner. Where a partner derives any profit for himself from any transaction of the firm or firm the use of property or business connection of the firm's name, he must account for that profit and pay it to the firm. A deed of partnership may contain a clause that some or all partners are not to carry any business other than that of the firm during the continuance of the partnership. Section 11, clause 2 of the Indian Partnership Act deals with that. A breach of such provision may entitle the other partner to recover the damages from the defaulting partner, but it will not give rise to any occasion for accounting to his co-partners for the profit earned unless the business is shown to be in rivalry with the business. Competing business only. Suppose I am running a hotel in a partnership business called, for example, say Dinesh Hotel or some hotel. Opposite to that, I am keeping one hotel in the same name. I am sitting there and telling that both are the same. I am the partner there also. So, in fact, it will be better here and prices are less also. These are rivalry businesses. Rights and duties of partners after the change of the constitution. Section 17 of the Indian Partnership Act deals with that. Change in the constitution can occur in one of the four ways, namely, where a new partner or partners came in. Very clear. Where some partner or partnership go out either by death or by retirement or insolvency. Third, where the partnership concerned carries on business other than that of the business for which it was originally formed. I told you the book selling and the book printing business. Then also the constitution has to be changed. Fourth right, where the partnership business is carried on after the expiry of the term fixed for the purpose. These are all in this condition, the constitution has to be changed. We will see rights and duties of partnership after a change in the constitution. Section 17, where a change occurs in the constitution because of the first three reasons, then mutual rights and duties of the partner remains the same. B, where the partnership business is carried on after the expiry of a term fixed for the purpose, so far they were consistent with the incident of partnership at will. Okay, here we are seeing the relationship of partners to third party, section 18 to section 20. The principal distinction between him and a mere agent is that he has a community interest and other partners in the whole property and business and liabilities of the partner, whereas agent has no such interest in either. Relation of partners to third parties. Partner is an agent of the firm for the purpose of the business of the firm. Cannot be applied to all transactions and dealings between the partners themselves. It is applicable only to the act done by the partner for the purpose of the business of the firm. Partner has implied authority to bind the firm by all acts done by him in all matters connected with the partnership business, which are done in usual way and not in their nature beyond the scope of partnership. If there is no usage or custom of trade to the contrary, implied authority of a partner does not empower him, one, to submit a dispute of the business of the firm to arbitration, as it is not the ordinary business, as it is not the ordinary business of the partnership. Second, open a bank account. Second, on behalf of the firm in his own name. Open a bank account on behalf of the firm in his own name. I'm going and opening in my name and operating without knowing others. Compromise or relinquish any claim or portion of a claim by a firm against a third party. That is an outsider. Suppose if there is my claim, some X owes this firm around some 10 lakhs. I'm settling that claim. Just I'm saying compromising, okay, you don't pay, I will tell. That is not allowed in partnership. Withdraw a suit or proceeding filed on behalf of the firm. If there is any case is pending in a court, I am withdrawing it without consulting the others. That is not allowed. That is beyond the authority as mentioned in section 19 of the Indian Partnership Act 1930. Admit any liability in a suit or proceeding against the firm. Suppose I was called to the witness box to give evidence. The partnership, we decided that we will, we will specifically deny. We will deny that. We will deny that claim. Specific, giving specific, these are the documents you give and deny. Enter into the witness box and give the evidence. I'm doing otherwise. I'm admitting yes, that what he says is right. That is not allowed. Acquire immovable property on behalf of the firm. Okay, it is clear. Transfer immovable property on belongings to the firm. Enter into partnership on behalf of the firm. These are all without discussing the other parts. Contractual liability, section 25. It is necessary that act of a firm in respect of which the liability is brought to be enforced against a party must have been done while he was a partner. It's a contractual liability. Liability for the tort or wrongful act. Section 26 of the Indian Partnership Act deals with that. The fact that method employed by the partner in doing it was unauthorized or wrongful would not affect the question. Furthermore, all the partners in a firm are liable to a third party for the loss or injury caused to him by the negligent act of a partner acting in the ordinary course of the partnership business. Liability for misappropriation by a partner. Section 27 provides that when a partner acting within his apparent authority receives money or other property from a third person and misapplies it, or where a firm in the course of its business received money or property from a third person and the same is misapplied by a partner while it is in the custody of a firm, his firm is liable to make the loss. Rights of transferee of a partner's share. Section 29 of the Indian Partnership Act 1932 deals with this. A share in a partnership is transferable like any other property, but as the partnership relationship is based on mutual confidence, the assignee of a partner's interest by sale, mortgage, or otherwise cannot enjoy the same rights and privileges as the original partner. The Supreme Court has held that the assignee will enjoy only the rights to receive the share of profits of assigner and not the account of profits agreed to by the other partners. The rights of such transferee are given below. 1. During the continuance of the partnership, such a transferee is not entitled to A. to interfere with the conduct of the business, B. to require the account, C. to inspect the book of the firm. He is only entitled to receive the share of the share profit of the transferring partner and is bound to accept the profits as agreed by the partners. That means and include, he cannot challenge the account. Who cannot challenge the account? The assignee cannot challenge that. That is made, Supreme Court also made clear in various landmark cases that I will, in my next session, I will talk about all these things. Okay. On dissolution of the firm or the retirement of the transferring partner, the transferee will be entitled against the remaining partner, 1A, to receive the share of the assets of the firm to which the transferring partner is entitled, and B, for the purpose of ascertaining the share, is entitled to an account as from the date of the dissolution. Okay, next slide. Okay, by virtue of Section 31 of the Indian Partnership Act 1932, which we will discuss here now, no person can be introduced as a partner in the firm without the consent of the other partners. As partner cannot, by transferring his own interest, make anybody else a partner on his partner on instead of him, unless other partners agree to accept that the person as a partner. At the same time, a partner is not debarred from transferring his interest. A partner's interest in the partnership can be regarded as an existing interest and tangible property which can be assigned. Okay. Introduction of a new partner deal with Section 31 of the Indian Partnership Act 1932. As we have studied earlier, subject to a contract between the partners and to the provisions regarding the minors in a firm, no new partner can be introduced into the firm without the consent of all the existing partners. That is Section 31. Okay, retirement of a partner. A partner may retire, 1, with the consent of all other partner, 2, by virtue of an express agreement between the partner, 3, in case of a partnership at will, by giving the notice and writing to all other partners of his intention to retire. Such a partner, however, continues to be liable to the third party for the acts of the firm after his retirement until public notice of his retirement has been given, either by himself or by the other partners or by the firm. But the retired partner will not be liable to any third party of the latter deals with the firm without knowing that the former was a partner. Subsection 3 and subsection 4 deal with that. However, the partner may agree with his partners that on his ceasing to be a partner, he will not carry on the business similar to that of rivalry business, that we mean rivalry business, that of a firm with a specified period within specified local limits. Such an agreement will not be in restraint of trade if the restraint is reasonable. Section 36, subclause 2 of the Indian Partnership Act 1932 deal with that. A similar rule applies to such an agreement of sale of firms goodwill also. Section 53, subclause 3 of the Indian Partnership Act deals with that. Okay. On retirement of the partner, he has the right to receive his shares of the property of the firm, including goodwill. Also, an outgoing partner where the continuing partners carry on the business of the firm with the property of the firm without any final settlement of the accounts with him, he is entitled to claim from the firm such a share of profit made by the firm since he ceased to be a partner, as attributable to the use of share of property of the firm. In alternative, we can claim interest of the rate. We can claim interest at the rate of 6% per annum on the amounts of his share in the firm's property, as mentioned in the Section 37 of the Indian Partnership Act 1932. However, if a contract between the partners, an option has been given to the surviving or continuing partners to purchase the interest of the outgoing partner, and the option, if duly exercised, the outgoing partner or his estate will not be entitled to any further share of the profits. Liabilities of an outgoing partner. What are the liabilities of an outgoing partner? The retired partner will not be liable to any third party of later deals with the firm without knowing that the former was a partner. Section 32, subclause 3 and 4 deals with that. Expulsion of a partner. What are these things? Section 33. How it is thus essential that 1, power of expulsion must be existed in the contract between the parties. 2, power has been exercised by a majority of the parties. 3, it has been exercised in good faith and not in malified intention. It should be with the bona fide intention. If all these conditions are not present, expulsion is not deemed to be in bona fide interest of the business. The test of good faith is as required under Section 33, subclause 1 includes 1, that the expulsion must be in the interest of the partnership firm. Second, the partner to be expelled is discontinued with the notice. that he has given an opportunity that his side has to be heard. Natural justice has to be followed. Right of outgoing partners, insolvency of a partner, section 34. When a partner in a firm is adjudicated as insolvent, he ceases to be a partner on the date of the order of adjudication, whether or not the firm is thereby dissolved. His estate ceases to be liable for any act of the firm done after the date of the order, and the firm is also not liable for any act of such a partner after such a date, whether or not under a contract between the partners of the firm is dissolved by such a adjudication. Section 35 deals with the death of a partner. In case of a death of a partner, where under the contract of a firm is not dissolved by the death of a partner, estate of a deceased partner is not liable for acts of the firm after his death. It means limited liability. After the firm entered into any of the, after the firm incurs some losses also, his share in that firm, that property or whatever it is, cannot be attached. Okay. So I think almost we covered all the topics of Indian Partnership Act 1932. Just some multiple choice questions are there. Those who are interested, just I will ask one or two questions. Just then I will conclude this session. Okay. One, can a company become a partner in a firm? There are two answers there given. You may tell, any one of you can tell the right answer. First, let me read out. It is there on the screen. Yes, a company is regarded as a person in legal sense of the firm. Second answer, no, as a partnership is an association of natural persons. Which is right? Yes. First one is right. A company can very well be a partner. Second multiple choice question. A partnership firm comes into existence by the agreement between all the partners, and such agreement should be A, express agreement only, B, implied agreement only, C, either express or implied, D, mixed. What is the question first? C, either express or implied. Yes. Partnership deeds usually contains particulars relating to name of the firm, nature of business and duration of firm, capital contribution, profit bar loss sharing relation, all this. What is answer? Okay. Answer is coming. All these. Then a partner is an agent of a firm for the business of the firm. True. Which is right? A is right. Mutual agency. Okay. Here. Which of the following statement is correct? Read it. A, B, C, D is given. Which is right? A is right. So this slide you may read it and answer it. Okay, so friends, herewith we are concluding the Indian Partnership Act 1932. If you have any doubt also, you may put it in that comment column. I request you to press that subscribe button and also subscribe and like, so that this you can view all the this thing and all this thing. Okay. With this, we are concluding this. Thank you very much for your patient listening.